Chair will put that down so people can hear me. We'll call this meeting of the Climate and Energy Committee to order. And for the record, we do have a quorum. And we have some minutes from January 18th. Representative Kraft, have you had a chance to look at those minutes?
I have, and I would move their approval, Madam Chair.
All those in favor of the minutes from the 18th signify by saying aye.
Aye.
Opposed, nay. The motion prevails and the minutes are adopted. So today we have another bill, and Representative Stephenson is going to present House File 393. Hi.
Hello, Madam Chair. I would move that House File 393 be re-referred to the Committee on Judiciary, Finance, and Civil Law.
Great. Representative Stephenson, do you have an amendment?
I do. I would move the A1 amendment, which is an author's amendment that gets the bill in the shape that I would like the committee to consider it in.
Great. Any discussion on the A1? Do you want to tell us about it, or is it better to tell about it in context of the bill?
In the context of the bill. Well, the amendment, it's not a substantive amendment, it's a technical amendment that results from some discussions between the PUC and stakeholders and gets us in the place that is a more workable concept.
Great. Why don't we go ahead then and we'll do the amendment first. Any other, I think I asked discussion on the amendment at all? Seeing none. All those in favor say aye.
Aye.
Opposed, say nay. The motion prevails and the amendment is adopted. Representative Stephenson, do you want to tell us about your bill?
Yes, Madam Chair, members of the committee, this bill, House File 393, is a relatively straightforward bill that fills a gap in Minnesota law. Presently, if a consumer brings a consumer issue to the PUC, there's not an avenue for sort of a final decision that can be then brought to a court in the event of a disagreement. We are the only state in the country that lacks that avenue for consumers to avail themselves of their rights, and would like to see that changed. For returning members, this bill will look familiar. We did have this bill last year, and I recall it being a fairly uncontroversial bill. I hope it remains a fairly uncontroversial bill this year. And to keep it a fairly uncontroversial bill, I'm going to keep my remarks brief so I don't get myself into trouble, and I'll turn it over to a much more skilled testifier, Mr. Elwood.
Good afternoon, Mr. Elwood. Would you introduce yourself for the record and proceed with your testimony?
Thank you, Madam Chair and members. Ron Elwood with Legal Aid. Really appreciate Chair Stephenson bringing this bill forward. Legal Aid handles, among many of its clients, folks who are at risk of disconnection or denial of essential utility service, and not a lot, but sometimes we identify legal concerns that we believe there's been some activity that is raising a legal question, challenging a tariff provision or a rule. And we have found ourselves in the situation of not being able to raise these legal tariff and rule questions before the Commission simply because of a strange confluence of current statute and rule, which essentially creates an impenetrable barrier. Once the consumer goes first to the utility, which this bill also codifies and requires. Second, goes to the Consumer Affairs Office at the Utility Commission, and they do a very good job for the most part, but occasionally we have questions that we believe the Commission ought to look at. The rules and law currently conspire against any consumer being able to bring that matter before the Commission, and this bill simply corrects that. I would say a couple of things before stand for questions. First of all, this will not result in floods of complaints coming to the Commission. 49 states have exactly the same statute. None of them have ever had any problems with an overwhelming, group of people storming the gates. So this is sort of a routine thing that we're getting in line with the rest of the country. Second of all, the few complaints that we would bring forward would it's very important for the commission to entertain because it's invariably, it's a matter of retention of utility service, which of course we need, everybody needs. Second of all, it will raise questions that do not only apply to that individual consumer, but they invariably are going to affect other consumers in that service territory, and in many cases, maybe every single utility consumer in the state. And those are issues that the commission would want, I think, to be able to adjudicate. So finally, before I close, I would really want to thank the Public Utilities Commission, the commissioners. Commissioner Sullivan is here, and I want to express my appreciation to him, and Executive Secretary Seifert, and the staff of the PUC who work with us to craft the language to make it fit with their current procedures. I want to thank all of the gas and electric utilities, Xcel, CenterPoint, Minnesota Power, Otter Tail Power. We worked with all of them. They are comfortable with this bill. And I would like to thank the Citizens Utility Board, the Minnesota Community Action Partnership, and the Attorney General. They have all expressed support. They have letters in your packets. And I thank you very much for the time. I'll stand for questions.
Thank you for your comments, Mr. Elwood. And any questions? I see Representative O'Neill.
Thank you, Madam Chair. I'm just trying to quickly go through the fiscal note. And I do note, I know you said that the number of complaints would be exceptionally low, but the fiscal note does say that we need 2 new FTEs, so 2 full-time people at the PUC to process this additional work, which if we're talking about 5 or 6 complaints a year, that seems rather excessive. So I'm just wondering if you can, either the author or if Mr. Elwood would help me understand the difference between the fiscal note and the testimony.
Well,
Representative Stephenson?
Madam Chair, Representative O'Neill, I'll say just briefly that when I look at the fiscal note, what I see is that assumptions that there's a large number of complaints that they're getting these complaints. They're based on prior years, and a certain number of those would be appealed to the PUC through the process created by this bill. They're estimating 5 to 10% or 25 to 50 complaints, and that 2/3 of them will be dismissed and 1/3 will go through the informal process, and an average of 1 case would go to a contested case later on. So I think that the numbers, as you kind of go further into the fiscal note, kind of line up with what Mr. Elwood was saying, but I would defer to Mr. Elwood to say further.
Mr. Elwood, did you want to speak any further?
Madam Chair and Representative Neal, I'm going to let the PUC talk about that. I can only talk from legal aid standpoint, and I can tell you in the last 10 years, maybe a half a dozen cases we would want to bring forward, if that. But the reason that this is here is because even though there are a few number of cases, and one could argue, well, if there's so few cases, why do you even need this? But the fact of the matter is, though every one of those cases raise critical, generic issues that are really important and affect a lot of people. And that's why we're here before you, to bring us in line with all other 49 states that have this right for residential consumers.
Representative O'Neill?
Thank you, Madam Chair. I'm wondering if the PUC could just help us understand why we would need 2 full-time people, even if it was the 25 to 50 complaints. It just seems like a lot of staff time, but maybe you can help us understand.
Sure, thanks.
Mr. Seifert, please state your name for the record.
Madam Chair, committee members, Will Seifert, Executive Secretary, Public Utilities Commission. I mean, we outlined our assumptions in the fiscal note. We thought we're being pretty conservative. We don't really have any idea how many will be appealed. In terms of the numbers, we took a stab at 5 to 10%. The staff time would be to process the appeals. And right now, we manage about 2,000 complaints in a given year. We develop a case record. This would require additional documentation and then the actual administration of the process to bring those appeals forward, which will take commission time. This is an estimate. This isn't a commission bill. This is what we thought reasonably we would need to actually implement the law if you guys pass it.
Representative O'Neill?
Thank you, Madam Chair. Right, so there's 2,000 complaints processed a year, and it's a lot. That's a lot of complaints. So I'm concerned that maybe we would see that increase substantially. Is there any concern with the PUC that would substantially increase from the 2,000 that you had in the prior year?
Mr. Seifert?
Madam Chair, Representative, I don't know if I'd say it's a concern, but certainly something we're aware of and would monitor. And this is not, we haven't done an analysis on other states to see. I think every state has a distinct way of processing complaints. So this is our, this is a conservative estimate on what it would take to do this.
Okay, thank you, Madam Chair.
Representative Stephenson.
Thank you, Madam Chair. I think, though it's worth noting, every state has a distinct way, but every state has a way except for Minnesota. We are a clear outlier here in that we do not give our consumers an opportunity to get a final agency action that they can, if they choose, take to a court. So we are an outlier in that respect.
We've got
Just really quick.
oh, sure, you bet.
Thank you,
Representative
Madam
O'Neill.
Chair. Just really quickly, I don't disagree with that. I'm just trying to reconcile two full-time people if we just had a handful of complaints. And so if you have a handful of complaints, but you've got two full-time people handling a handful of complaints, I was just trying to reconcile the two. So I appreciate that. Thank you.
Next on the list is Representative Carroll.
Thank you, Chair. And this question's for the author. Under subdivision 4, judicial review, I'm familiar with most cases where when you exhaust your internal appeals, you then go to the Court of Appeals if you're going to go for judicial review. In this case, you have it going to district court. So I wonder if you can explain the thinking, the reasoning, the rationale for that.
Representative Stephenson.
I'll defer to Mr. Elwood because he just whispered in my ear that he has that one. So.
Mr. Elwood.
Madam Chair and Representative Carroll, you're correct that the PUC's decision is tantamount to a district court decision, and therefore the appeal typically goes to the Court of Appeals. But all of the complaints in that category are big-ticket kinds of things: rate case complaints, transmission line complaints, environmental reviews. These are individual consumer complaints, and it was thought to the folks who were my colleagues at Legal Aid and elsewhere that it made more sense to send a complaint of this nature through the regular process to the district court first, and then obviously if that was an adverse decision, it could be appealed then to the Court of Appeals. But the nature of these complaints seemed to be more suited initially for going from the commission to the district court.
Okay, I appreciate that. I'm just,
Any follow-up,
yes,
Representative Carroll?
thank you, Chair. So in other complaints where they're appealed, they go to the Court of Appeals. For example, in the health context, if there's a health dispute, it won't go to a district court, it'll go to Court of Appeals. I'm just not used to seeing district court have jurisdiction over this, and I just was wondering the reasoning. I don't dispute that, I just wanted to understand it. Thank you.
Representative Elwood, sorry, Mr. Elwood.
Madam Chair and Representative Carroll, actually, there have been many cases over, not many, but there have been many cases over time where there have been disputes in other contexts around utility service, municipal utilities, about passing on bills, for example, from one customer to the next, and liability, that have begun at the district court level and that have worked its way up through to the Court of Appeals or the Supreme Court. So it's not unprecedented, but I think you're right. I mean, in this arena, typically a commission decision is appealed to the Court of Appeals. But as I said, it just seemed to make more sense with the nature of these complaints to start at the district court level, and there won't be many judicial appeals. And one more thing, Representative Neal, just to follow up on some of the things that you were talking about, I mean, certainly no disputing the commission's analysis, and, obviously. But I just want to point out that in order to even get to first base here, you have to raise an issue, a rule, a complaint about, a dispute about a law, a legal dispute, complaint about a rule or a tariff. So there is almost, there's sort of an inherent screen before you can even get to the commission. And also, the bill also provides for giving the commission the exact same authority they have today with any other complaint, whether it's brought by the Department of Commerce or another utility against another utility, in the sense that the commission could dismiss the case for having no merit right away off the bat, or they can decide to institute an informal proceeding or a contested case. I appreciate the analysis. There would be one case going to contested case. I'm not sure that may even be an overestimate, because I can't even see some of this kind of a case ever get into a contested case. But of course, it's not impossible, and we give that the option. But it's the same option the commission has today for every other complaint.
And it looks like a brief follow-up from
Just wanted to-
Representative Carroll.
Thank you, Chair. I just wanted to make the observation that I'm sure the Court of Appeals would appreciate this provision. And district court may not. But like you say, there won't be very many, right? So it'll be a diluted effect.
Next
Thanks.
on the list is Representative Swazinski.
Thank you, Madam Chair. And just kind of a general question, too. So if I understand this correct, so we're essentially in these court cases, so you would go to, if you had a dispute, you're currently not allowed, but you do have an option to go into district court, correct?
Mr. Elwood.
If you have a dispute with your utility.
Mr. Elwood.
Madam Chair and Representative Swazinski, actually not, because as I said, the strange confluence of rules and law prohibit that. In order to get to the district court, you have to have a final determination from the Public Utilities Commission. If you can't get before the Public Utilities Commission in the first place, you can never get a final determination, and therefore you cannot go to court. We've had this situation before where we have actually tried that and been shot down because we don't have a final determination from the adjudicative body of the administrative body. And so the answer is no, you can't do that.
Representative Swazinski.
And then my second question kind of goes to, as far as the connection, so consumers will be, so if you're under the current situation, from looking for what's the average estimate in other states of the length of the appeal process that you've seen? So if we're forcing utilities to provide electricity to folks that aren't paying their bill, what's the average length of this process? What have you seen in other states?
Mr. Elwood.
Madam Chair and Representative Swazinski, I didn't do an analysis of that, but I can tell you, before I came here in my previous life, I spent 15 years with the New York State Public Utilities Commission, and I was doing just this very thing. And I can tell you, and the volume of complaints there was significantly greater than here, and the time from informal complaint to formal complaint at the commission and the adjudication was pretty quick. I mean, we're talking weeks.
Representative
So,
Swazinski.
the reason I'm asking that question, because, obviously in the last 3 years, we've extended that period of time that, through wintertime, that you can't shut off people's utilities or shut off whatever that might be for non-payment. And, and we've heard from utilities that that's been used as a tool, that people understand that that's what they can do, and they get away with it by simply using that as a cash management tool on the backs of other ratepayers. That this would potentially elongate that process, that, even if you're outside of those parameters, so let's say you're into, it goes till April or May or whatever, let's say you've not paid all winter, and then you decide you get to April, now I want to use that as another tool then to just simply start an appeals process that you won't, so you can get by without, until your lease is up, and then you move out, and then just never pay. Because are utilities allowed to follow non-payment payees from address to address to recoup those costs?
Mr. Elwood.
A couple of things. Answer your last question first. Yes, they do. They can deny service at a new address for failure to pay at an old address. That's number one. Second of all, there's a big misconception about Minnesota about the cold weather rule that you can't shut off people during the winter. That is not true. You can. The cold weather rule requires payment from customers, low-income customers. And first of all, the cold weather rule only applies to low-income customers and requires at maximum at maximum 10% of your income. So you have to pay something. So utilities can shut off. They typically don't, because they're good people and they don't want people to die. But on the other hand, they can't. So, And then the second thing, the last thing I want to point out is that on lines 323 to 331, it does provide a number of requirements for the pendency, for the continuation or restoration of service during the pendency of the appeal. So you have to do something. You have to pay something, you have to agree. There's all sorts of things in here that would go to your very question of just sort of trying to evade payment and try to stretch it out. And I can tell you, nobody, I can only talk for legal aid, obviously. I can tell you with absolute certainty, no one at legal aid would represent a client who is seeking simply to avoid payment. It would be simply because there's a question of law that we're raising, a question of violation of a tariff or a rule, or an unreasonable act in practice, which is the parameters of the current complaint system for everybody else. So I'll just stop at that.
Representative Swazinski.
Thank you, Madam Chair. Just, this would be more, I don't know if there's anyone from the utilities here, but, from a cost of representation, the time before, so obviously you'd be a lawyer fees, lawyer costs, that, I'm not sure how that relationship works with you and your potential client. But, what is, if you've got a lawyer from Excel or a lawyer from any other investor-owned utility, what is the increased cost to ratepayers that potentially get passed on, just from a staff period of time? Because if we're looking at, two staff people to represent at the PUC, then what is the cost of, regulated generators to essentially represent their side or represent their position?
Mr. Elwood.
Madam Chair and Representative Swazinski, I would argue that the cost is zero because for several reasons. First of all, they're doing that now with complaints on every other type of complaint, and these are salaried employees, so that's what they do. So these are attorneys, there aren't fees. In terms of legal aid does not charge fees. That's our mission in life, like the public defenders, for people who can't afford lawyers. But if it wasn't a legal aid client and another ratepayer came with a complaint, that ratepayer would be paying their own lawyer, and that would have no impact, zero impact on rates, or anybody else wouldn't have to pay for that.
Seeing no further, Representative O'Neill.
Sorry, just a really quick follow-up. I've been going through this fiscal note, which unfortunately, I just am looking at it now. And I appreciate what Representative Carroll had just said about going to district court, but I don't see any part of the fiscal note that references what the district court cost might be. And having served on the Judicial Committee quite some time, not currently, but in the past, I do see it in their reference as to what the bill does. I mean, it's there on page 5, and it mentions Section 2, Subdivision 4, that it does go for judicial review, but I don't see anything from the court saying if they would incur any additional cost or need.
And to be clear, it's going to the Judiciary Committee next, but if there's a brief response, we can certainly.
It is going, Madam Chair, Representative, it is going to the Judiciary Committee next, but I think if you think about to continue to refine that down to, one case potentially going to the district court, I'm not sure that that's something that they're going to note, but we'll see. And we're going to the Judiciary Committee, and if they have an issue,
Did you have a follow-up, Representative?
Really quick.
Okay, go ahead.
Yeah, I realize that we're not the Judiciary Committee, but normally the fiscal note is fairly complete, and they did reference it. So you're a very thorough person, Representative Stephenson, if you would just maybe check in with the Supreme Court and just say, can you just take a look and just avail us of any concerns?
Representative Stephenson.
Yeah, Madam Chair, Representative Neal, happy to follow up on that. I think usually the fiscal note process would have reached out to them, but maybe they missed it. We'll follow up.
I don't see it. I don't see the review. I'm sorry.
You're all
My
good.
apologies.
You're good. And any closing statements about your bill, Representative Stephenson?
Madam Chair, I think this is a place, I think Minnesota is exceptional, but I don't think we want to be exceptional for this reason, so I'd ask for a yes vote.
So Representative Stephenson renews his motion that House File 393, as amended, be re-referred to the Committee on Judiciary, Finance, and Civil Law. All those in flavor, nice. All those in favor, say aye.
Aye.
Opposed, say nay. No. The motion prevails and the bill is re-referred. Thank you, Representative Stephenson. And next on our agenda, we are going to have a presentation from the Public Utilities Commission. We will welcome Commissioner Joe Sullivan and Will Seifert, Executive Director for the Utility Commission. Welcome. Please state your name for the record and proceed with your testimony.
Thank you, Madam Chair. For the record, Will Seifert, Executive Secretary, Public Utilities Commission.
And I'm Commissioner Joe Sullivan from the Minnesota Public Utilities Commission. Nice to see everybody here today.
Thank you for the opportunity to be here and give a little bit of an overview of the Public Utilities Commission, what it is we do. We're going to tag team this presentation, and now that you all know what our Consumer Affairs Office does, we'll shorten that part up, but we'll do the rest of it. So there we go. All right. Well, with one of the smallest commission staffs in the country, the Minnesota Public Utilities Commission regulates the rates and services of 3 cornerstone industries in Minnesota's economy: electricity, natural gas, and landline telephone utilities. The Public Utilities Commission is Minnesota's oldest regulatory body. It's changed a lot since it was formed more than 100 years ago, where it originally began its life as the Railroad and Warehouse Commission, formed in 1871. Today, our primary responsibilities are to make sure that Minnesotans can get safe, reliable, and affordable electric, gas, and telephone utility service. The decisions of the agency impact the lives of Minnesotans in a variety of ways, whether that's the rates charged by state-sanctioned monopolies, the quality and reliability of electric, natural gas, or landline telephone service, or the quality of life for those who live nearby energy generation and transmission, to name just a few. The Commission recognizes the importance of these decisions and does so in adherence to the general and specific directives laid out in Minnesota statutes. So statutes vest the power of the agency in 5 commissioners who are appointed by the governor and approved by the Senate to serve staggered 6-year terms. The governor selects the commission's chair, whose term is concurrent with that of the governor. The chair functions as the principal executive officer of the agency and has statutory authority to preside over the commission's meetings. Statutes give administrative authority over the agency to an executive secretary. Our current membership is, in addition to Commissioner Sullivan, who lives in the 1st Congressional District, Commissioner Means lives in the 2nd Congressional District, as well as Commissioner Tuma. Chair Sieben lives in the 4th Congressional District, and Commissioner Scherger lives in the 8th Congressional District. I want to emphasize that the Commission is not a cabinet agency, but rather is independent from the administration. So there's a quid pro quo in statute, also referred to as the regulatory compact. The state requires public utilities to provide safe, reliable, and essential service to ratepayers. In return, utilities are entitled to recover the cost to provide that service, plus a reasonable return. One of the Commission's primary tasks is to determine what a reasonable cost of service is for the investor-owned utilities, and to decide how much of that cost should be paid by different customer classes. PUC's authority over utilities is primarily limited to for-profit companies that are owned by investors. PUC does not regulate most aspects of municipal utilities or electric cooperative associations. Municipal utilities and cooperative associations, however, may elect to be regulated by PUC. PUC currently regulates 1 co-op, Dakota Electric, in addition to 8 investor-owned electric and/or natural gas utilities. Regarding telecom, we regulate more than 300 telecom companies, but don't regulate rates for any of them. PUC's regulatory authority over electric and natural gas utilities includes setting utility standards and rates, approving utilities' long-term plans, and ensuring service quality, among other things. So service quality for electric and natural gas service, it includes issues like reliability and disconnections. This includes service quality dockets for all regulated utilities, where we examine the frequency and duration of outages, customer service, et cetera. Rates for investor-owned utilities and other utilities whose members choose it. This includes rate cases, riders, and other financial proceedings. And rates must be just and reasonable and non-discriminatory. Resource selection. So this is what types of resources that are used to generate power. This refers primarily to integrated resource plans. which is the size, type, and timing of utilities portfolios over the next 5 to 15 years. And large energy facilities dockets, this includes, we refer to these as facilities dockets. This includes certificates of need, site and route permit proceedings for high voltage transmission lines, power plants, large wind energy conversion systems, large solar, and pipelines, now including carbon dioxide as well. And this bill, it also applies to non-utility infrastructure. Local telephone companies and long-distance carriers, known as IXCs, there's been significant market transitions as people move away from traditional telephone service to cellular and VoIP. But as I noted earlier, our primary authority is around service quality. A quick note on the non-regulatory work. All Minnesota investor-owned utilities are members of the the Mid-Continent Independent System Operator, known as MISO, our region's wholesale power market and transmission organization. PUC actively participates in MISO and FERC proceedings as an individual member and as part of the organization of MISO states to protect and promote states' interests and influence regional transmission planning and wholesale market policy. This is done in coordination with Minnesota agencies, as well as Minnesota utilities and other Minnesota stakeholders to promote Minnesota's interests in wholesale energy market design and regional transmission planning. Turn it over to Commissioner Sullivan here.
Thank you, Will. Thank you, Will. We've broken out this section by 3 principal areas, but commission decisions help ensure that utility service is reliable and available as needed. And this starts with resource planning. Resource planning really is the bedrock of how we plan for utility service, also referred to as integrated resource planning. You'll also hear people talk about IRPs a lot, so that's what we're talking about. And that is the process where a utility, the commission, and stakeholders, those stakeholders are the utilities, they are environmental organizations, customer advocates, large power. They examine the utility's current and planned electric generation for the next 15 years. And then ultimately, the commission then approves the size, the type, and the timing of electricity generation, and that thereby ensuring electric customers have affordable and reliable service. This is foundational for a utility to invest in the generation and transmission assets that are needed to ensure a reliable system. The Commission ensures reliability through a number of other proceedings as well, including distribution planning, service quality dockets, grid modernization, amongst others. And really, reliability is the core of the work that is done on a regular basis at the Commission. In addition to the Commission's docketed work on reliability, the Commission is also heavily involved in federal and regional organizations, as Will had said, that shape the bulk power system. This includes our work at the FERC, the Federal Energy Regulatory Commission, NERC, the North American Reliability Corporation, MISO, the Mid-Continent Independent System Operator, which is the regional transmission operator that spans that Minnesota is a part of, but that spans from the Gulf of Mexico to the Hudson Bay. SPP, which is the RTO that is to our west. I'm Minnesota's, the PUC's representative to MISO through the organization of MISO states, and then Commissioner Tuma serves as the Commission's representative to SPP. The decisions and investments made at regional and federal level have a significant impact on Minnesota customers, and the Commission works to represent and advocate for our state's interest before these bodies. One way that folks can measure the way that our reliability work is through what's called the SAIDI index. SAIDI it's a System Average Interruption Duration Index. That's the chart that you see there. I think the key takeaway is that Minnesota is doing better than the national average. That's what I want you all to take away. This is a measure of how quickly the lights get back on for Minnesota customers when power is interrupted, and our utilities are doing a better job than the national average. So that's tremendously important, and that's a testament to the power of the regulatory compact. The next slide on affordability. Affordability in the our commission's decisions help ensure that Minnesotans pay reasonable utility rates that are below the national average. There are a couple things on this that I want to focus on. Minnesota statute allows for utilities to recover the cost to provide for safe and reliable electric and gas service, plus a reasonable return. These are the rates that are set by the commission and updated every time a utility petitions for a rate case. And some recent rate decisions by the commission that I think are important for you to know. Just yesterday, we determined Minnesota Power's rate increase. They proposed a $108 million increase. We ultimately settled at around $58 million increase in rates after an extensive review. 15 hours of testimony and deliberations got us to that point. That will result in approximately a 9% rate increase for Minnesota Power. The Otter Tail rate case, which we resolved last year, was a 0.5% rate increase for Otter Tail. We have a Center Point settlement, which is 3.9% increase. And coming this year, XL Gas will have a rate case, the XL Gas utility, scheduled for March, and XL Electric in June. I think it's important, and I want to give you the way that I think about this, and I'm going off script here a little bit, so Will might have a little bit of a heart attack, just kidding. But I think it's important, when you think about bills, the way that I think about bills and the way I think about rates is to use this and keep this in your head. Everybody in the state pays a rate for electric service, and don't take this with every utility is a little bit different, but the way that rate is built is about 1/3 of that comes through base rates. That's what we worked on yesterday through Minnesota Power. About 1/3 of that's in base rates. About 1/3 of that comes from riders, and you'll hear utilities talk about riders a lot. Riders are mechanisms that you specifically approve, that the commission then reviews with the Department of Commerce, that allows for rate recovery in between when a rate case comes. So rate cases only come every couple of years, but utilities still want to recover their legitimate costs in between. So that's what a rider is. So about 1/3 of that rate comes from a rider. And every time we do a rate case, we basically true up those riders and bring them back into base rates. And then about another 1/3 of that rate, in some cases it's up to 40-45%, is the fuel charge. And we have no control over that. That fuel cost that flows through to Minnesotans that's how, when the price of natural gas goes up, people can feel it so immediately, even though we set rates. The base rates, the riders don't change, but the fuel clause will change. So I think that's an important way to kind of structure thoughts on how this works. So that fuel clause, those are automatic adjustments, and they flow through fuel clause adjustments for electric utilities and purchase gas adjustments for natural gas utilities. So I think it's important to take a look at how we're doing on this. Minnesota law establishes a goal for retail electricity rates for the utilities, for each customer class, to be at least 5% below the national average. The graphic here provides a comparison of Minnesota residential bills to the national average. For all of our investor-owned utilities, electricity rates and customer bills are consistently, for all of our IOUs, electricity rates and customers and consumer bills are consistently greater than 5% below the national. They're below the national average. However, there has been a steady increase in industrial rates for industrial customers, and that's one area where they are exceeding the national average, and it's something that we're very focused on, and we continue to examine. Before leaving this slide, I do want to highlight two other things that are important to affordability. Since 2020, the market price of gas has steadily increased, and as I said before, that flows through people's bills. The price of gas right now is roughly 2 to 3 times more expensive than it has been on average over the past decade. And this is having a significant impact on consumer bills here in Minnesota and throughout the country. Additionally, the price of gas is putting upward pressure on electric bills as gas plays a significant role in electricity generation. I also would like to mention that one thing in 2022 that the commission, we were the only state in the union to have done this, that the commission opened an investigation into Winter Storm Uri, and the result of that investigation was that the commission denied approximately $60 million in costs to be recovered from Minnesotans. Unfortunately, it was a $660 million bill, so there's still a very significant portion of that that is passing through to customers from that price spike event from a couple years ago. And then lastly, focusing on other policy goals, we have spoken greenhouse gas emissions. We have spoken about resource planning already. But one thing I wanted to focus on is the agency, how the agency has worked to help the state meet its carbon emission reduction goals. Through energy facilities, permitting proceedings, the commission determines the need for and approves the location of and sets additional conditions for these facilities. One recent example of our permitting decisions driving CO2 reductions is our approval of the Sherco Solar facility this fall. The Sherco Solar project will avoid an estimated 250,000 to 300,000 tons of CO2 emissions annually. In addition to the permitting activities, the Commission has overseen the development of EV pilots, distributed generation, and a host of related proceedings that shape the carbon footprint of Minnesota's power sector. On to the next generation, as you know, the Next Generation Energy Act sets a goal for statewide greenhouse gas emission reductions of up to 80% from a 2005 baseline. The Commission is working to ensure that our Minnesota utilities, through their resource planning, their long-term planning, are tracking and exceeding those goals. So,
Thank you.
Will?
Thank you, Commissioner. A couple more slides, if you could bear with us. So Commission has a total annual general fund budget of approximately $8.3 million. Nearly 100% of the agency's expenditures are recovered through Special Assessment Authority and returned to the state general fund. The agency also administers the telephone assistance program from a special revenue fund. Reimbursement grants are provided to telephone companies who assist their eligible low-income customers with reduced rates. Generally, more than half of the Commission staff work in the Regulatory Analysis Division. Regulatory analysts from that division are responsible for analyzing and interpreting the issues that go before the Commission to help the Commissioners make decisions. These are economists, accountants, public policy specialists, and experts in related fields. The Regulatory Analysis Division is made up of 3 subunits. Here you can see on the slide, there's the Financial Analysis Unit. They handle rate cases, rider filings, and other financial proceedings. The Economic Analysis Unit handles telecommunications, utility long-term planning and service quality, and other emerging energy issues. And the Energy Facilities Permitting Unit handles energy facility permit applications. Agency also has 3 other units. The Legal Unit drafts the Commission's orders and provides advice. The Consumer Affairs Office, which the last bill pertained to, mediates complaints about utilities from utility customers, provides outreach and assistance with cold weather rule, TAP enrollment, federal lifeline program, and other related programs. I just want to make a note here. You are welcome to refer your constituents to our CAO team to resolve utility disputes and related matters. They work tirelessly on behalf of consumers as they're contacted to deal with very difficult issues with utilities. Then we also have a business services unit that manages the agency's operations and finances and provides general administrative support. I just want to spend a couple minutes on this slide because this is a really important slide as we are unique in our structure. We're different from most state agencies for a couple reasons. One is that we have a group of 5 commissioners instead of only a single decision maker. So this means we're subject to the state's open meeting law, which promotes transparency but also places limits on how the agency makes decisions. In general, when the commission is making a decision or receiving information that could be relevant to a decision, that needs to be done in a publicly noticed meeting. The other reason is that we operate more like a court than a policy-setting agency. The vast majority of our work is responding to requests from utilities, customers, or other groups, and resolving disputed issues like a panel of judges would resolve a court case. Also, like a judge, we base our decisions on specific factors that are established in law. These factors that can apply change in different types of cases, but they're always based in the law. In order to preserve the independence and objectivity of the process, the Commission has some ethics rules that strictly limit what commissioners and staff can talk about. Simplest way to understand the rules is to imagine the Commission was actually a judge. You wouldn't want a judge to run around having private conversations with people about individual cases, and there are rules that govern us that prevent that. The most restrictive is the ex parte rule. It totally prohibits commissioners from having discussions about material issues with parties or participants in a disputed case. The Commission also has a code of conduct that is more general, requiring that commissioners and staff act in a way that promotes public confidence in the integrity and the impartiality of the agency. The Commission needs to be able to make independent decisions, and the public needs to have confidence that these decisions are actually independent. Before moving off this slide, I also want to highlight the roles that other agencies and parties play in Commission decision-making. The Department of Commerce plays a big role in front of the Commission, serving as the public advocate, providing analysis into the record on all matters that come before the Commission. The Office of Administrative Hearings administers some of the public participation processes for PUC proceedings. The Commission refers certain types of cases to administrative law judges, and they develop the official record for those cases by holding hearings. ALJ will then issue a report to the Commission with findings of fact, conclusions, and recommendations. In addition to these agencies, there are also a number of institutional advocates, government, non-government, for-profit, nonprofit, that represent the public in different ways before the Commission and play a vital role in building a comprehensive record, as well as public commenters. The Commission heavily relies on the participation of so many different voices in evaluating the administrative record. And this is almost my last slide, so thank you for your attention. Now that we've kind of gone over some foundational information about our structure, process, and jurisdiction, I just wanted to touch on some highlights. We manage about 900 utility filings annually. Over the last 10 to 15 years, the complexity and scope of these roughly 900 filings has grown as the energy industry is in transition. And the same can be said about the nature of customer complaints and inquiries. I do want to note here this number varies a little bit from the fiscal note because this incorporates both consumer complaints and inquiries, whereas the fiscal note was tailored to just complaints. As you can see here, since the pandemic started, we moved to a remote way of being able to do business, and then we quickly moved into a hybrid model that now we offer for all of our meetings. So all Commission business now is done both in person with remote options for public participation, which has really helped expand and encourage additional participation. We've refreshed our website recently to improve public access, and then have been implementing a tribal consultation policy since 2019. So with that, I think I will go ahead and close. I'd encourage you to follow us on social media. We put together and circulate a monthly newsletter, which provides summaries of Commission decisions, highlights upcoming meetings. If you haven't already subscribed, I would encourage you to come to our website and subscribe. But I really appreciate your attention today, and thank you for the opportunity, and we're certainly available to answer questions should you have some.
Thank you to both Mr. Suffert and Commissioner Sullivan. I have a really quick question before I turn it over to members, and it's about the telecom role, and I know this is the Energy Committee, but just recently been at legislative priority events with the cities that I represent, and one of the issues that has come up is around small cell, and I know telecom, it said I think you indicated your primary authority is around service. Do you have any jurisdiction around, or do cities have any authority to help siting for small cell towers?
I'm fairly certain we don't, but I will check and get back to you.
The committee might be well versed on that. It'd probably be a pretty quick answer.
Well, we can talk about it. We'll go offline and talk about that. I just was wondering if it was within your telecom jurisdiction, and if not, I'm happy to talk offline with Representative O'Neill. But just that caught my ear, given a recent conversation. So we'll go to members' questions. First up is Representative Swazinski.
Thank you, Madam Chair, but Representative Garofalo has to leave shortly, so
Oh,
if I could just let him go first. So,
Absolutely.
yeah, thanks.
Thank you.
Very kind. Representative Garofalo.
Thank you, Madam Chair. Commissioner Sullivan, it's good to see you.
see you.
It's been a while, and never missed the opportunity to ask the rabidly partisan Joe Sullivan any questions. So that's a joke. He's not rabidly partisan. The lack of laughter from the audience frightens me, Commissioner. Maybe I don't know something. I do want to ask you some questions. First of all, you made some comments about natural gas pricing.
Yep.
2-3 times what are you talking about?
Commissioner Sullivan.
Sure. Madam Chair, Representative Garofalo, the price of gas on the system has gone up 2 to 3 times.
Representative Garofalo.
Madam Chair, Representative, or Commissioner Sullivan, I double checked because I thought like maybe something had happened I didn't know about. Henry Hub is $3.20 an MCF.
Well, that might be the price at the moment, but I think when you look at when I'm making that claim, I'm talking about the price over the last over the last 2 years has been double on average than the historic decade before it. And we can get you those numbers. I'm happy to do that. And I can point you to, MISO has indicated that the price of gas, as reflected in the wholesale energy price is a major driver, and it is about 2 to 3 times.
Representative.
But I understand that's a snapshot in time when you're looking at that price, and the price has eased off a bit lately. But I'm happy to get that information for you.
That would be helpful. Thank you. We can maybe share it with the whole committee. Representative Garofalo.
Yeah, thank you, Madam Chair. And Commissioner, I do think it's important for members to take a look at natural gas pricing going back, not just at what its all-time low was when they were flaring it in North Dakota, but also as we've been using more and supply has been artificially choked off, natural gas was even when it spiked recently, in the last couple of years, was still cheaper than it was back in 2008. And so I think that the committee is being left with this is a relatively new committee with energy policy understanding. I think they're being left with this misunderstanding that natural gas is more expensive than it used to be. I think that to say that it's 2 or 3 times higher is picking out an anomaly in both the low cost and the high price. But maybe I'm being harder on you, Joe.
No, that's okay. I think it's a fair question. And I think when you do look at natural gas prices going back multiple decades, we're still low relative to 2008, 1998. We're still low relative to that. You're not wrong on that point at all. But when you go back 5 years ago, the price of gas is considerably higher than it was 5 years ago. And as reflected in the prices that we see on the market today, that's what I'm making the comment.
And Madam Chair and Mr. Sullivan,
Representative
just
Garofalo.
when you said I wasn't wrong, that's all I needed to hear. That mattered. So I do want to, on your presentation, I want you to go to, if I could ask, could you please go to page 7 on your presentation? This is something that's been brought up numerous times before, and it keeps showing up over and over again. So we are given a graph that shows us affordability, and we are shown the Minnesota investor-owned utility residential bill average compared to the national average. And this is a highly misleading graph for multiple reasons. Number one, Minnesotans do not use as much electricity cooling their homes as the vast majority of the nation does. So that is an inaccurate measurement. Second of all, when Minnesotans do consume more energy in the winter for heating, we are more likely to use natural gas than most other states in the country. They're more likely to use, not all, but most are using electric for their heat. So I would expect that our residential bills should be substantially lower than when we compare on a household by household basis. But this graph provides the misconception that by focusing on bill average, which is an inaccurate metric, that we do not have a problem with home residential electricity prices. And the reality is we do. The rates that we've been paying for home residential rates, I'm aware of the commercial and industrial numbers, but the home residential rates have been rising much faster than the rate of inflation and much faster than peer states across the country. So I'm not admonishing you, Commissioner Sullivan, but this is a misleading graph that would, for again, the committee would be under the mistaken impression that our home residential energy prices are lower than the nation. They're not. We've lost our gap, and we're paying more now than the national average. So is there anything wrong I said about that?
Commissioner Sullivan.
I think there's nuance and subtlety. My response to that would be that the primary reason that energy usage in Minnesota is lower is because we have really well-run conservation programs. And I see the groan, but I mean, I will stand by that. Minnesota's utilities run exceptionally good energy conservation programs, and those kilowatt hours that are removed from the calculation because people are using less are why bills are lower, and bills are lower than the national average. And our bills are lower than our peer states next to us. Wisconsin, North Dakota, South Dakota, our bills are lower, and their energy profile is very similar to ours.
Madam Chair.
Representative
And thank
Garofalo,
you.
anything?
Commissioner Sullivan, it's good to see you. And you're right that the cheapest and cleanest form of energy is the stuff we don't consume. So you are right about that. But it's nice seeing you.
Nice to see you,
I got to go
too.
to my next meeting, so
Have a good one.
you too.
Next up is Representative Swazinski.
Thank you, Madam Chair. Just, I understand that that's part of your answer, Commissioner, to, say, well, we have all these other programs, although we're not reaching our goals, which is a goal, just as the 25 by 25, it's right there on the list that, we're supposed to be, our rates should be 95% of the national average, which they're not.
Was it
That
Representative,
is the goal, and
Sullivan.
you're right. I'm not going to disagree with that.
So
Representative Swazinski?
what, you demand of utilities to reach the other goals. And through that, what are you doing as a commission to approve projects to follow that particular goal as well?
Commissioner Sullivan.
Like, what is your plan to work with utilities so that that is the standard by which that they move forward with projects?
Sure. I mean, this is a really good question. It's a hard question, and my answer is going to be complicated, complex, I think, because I'm really trying to respond. But when you look at the goal that our utility rate should be 95% of the national average, or 5% below the national average, that's why I did that pie chart before, is that when you look at an average person's rate, it encompasses all three of those pieces: base rates, riders, and fuel charge. And a very significant portion of the run-up in rates right now is because the fuel charge is higher and has gone up significantly. When you look at the way that we are working hard to ensure that Minnesotans are paying just and reasonable rates, that is the law. The law is that that people pay just and reasonable rates, and that we only allow investments into the system that are prudent. That's the law, that our rate laws. When we apply those standards, and then we think about the different goals that we have, we have to make sure that we are scrutinizing every dollar that a utility is spending and wants to include in rates. So when a utility brings us a rate case and, we disallow half of the rate case or half of what they're requesting, that's one way that that's a very concrete way that we're trying to reduce rates, is ensuring that, that we are scrutinizing every dollar that they are requesting. When we put, when we look at their rate of equity that they apply to what they own, that's their return on equity, we make sure that that is an appropriate market-based rate. So scrutinizing everything that the utilities bring to us. An important way that we are going to address utility rates in the future, I personally believe, is by making smart use of our investments to ensure that, every time we're investing in resources that have zero fuel clause, that's the control that we have over the fuel component of our bill. So if we're investing in wind, and wind has no fuel charge, we are at the same time simultaneously bringing down that fuel charge bill that comes back to us. So there are a number of ways that we are trying to address rates in Minnesota. I mean, I know that Representative Garofalo has a little different take on this, but the conservation program is a key metric and, or key program and key framework for helping make sure that Minnesotans' usage is low and their bills are low, and at the end of the day, people pay bills. And, you know, our bills for most Minnesotans are below the national average. And, you know, I understand what you're saying. I think about that every day. And, you know, we just got out of a rate case where we scrutinize every dollar that the utility wants to spend. But the utility at the end of the day is who brings us the proposal, and we have to scrutinize it. We are fundamentally a reactive agency. We cannot proactively go out there and tell the utility, bring us something that reduces rates 5% below the national average. That's not what we can do. But I don't know if that answers your question, but that's my answer.
Kuzinski.
Thank you, Madam Chair. But couldn't, I mean, from a regulatory agency or board, can't you just simply deny plans that don't?
Commissioner Sullivan.
Sure.
I mean,
Chair,
as a
Representative
tool?
Kuzinski.
I mean, if you're reactionary, you know, you say, well, you didn't bring this to us. Like, just like you said, well, hey, you came to us with a 20% increase, Xcel Energy, over a 3-year period. We don't believe that's right. Come back with a plan that still reaches all those other goals, but also reaches this goal, and then come back, because you're not doing it.
What we can do is, we cannot, if an investment is otherwise prudent and therefore compliant with state law, if a utility comes in and they have a distribution system that has to grow and has to build out, and those prices have to be, those figures have to be included into rates, because, you know, a huge 300-acre subdivision was built, and that needs to get included into rates. We can't say no, but that gets included into rates. That's a prudent investment. So what we have to do is what types of tools do we have to reduce rates, to get to making sure that our utilities are making good with the goals. The tools that we have are scrutinizing every dollar that the utility wants to spend, and that is consistent with the prudency standards that we have in state law. Ensuring that the resources that are added to the system, to the extent possible, are reducing rates. It's when folks in the renewables community say that renewables, they reduce rates, they're not wrong. I mean, that not having a fuel price is a way that you reduce rates. So, I mean, the tools we have are not, I don't have that big hammer, boom. I have multiple levers, and how you switch them and move them around has to be judged. We have to work, we're working within a framework, and we're weighing lots of things.
Representative Swazinski.
Thank you for your indulgence, Madam Chair. I appreciate it. Just want to flesh out that kind of that prudency side, you know, of the argument. So essentially what you're saying, so let's say a utility came forth with a source of natural gas that was 3 times, you know, you mentioned, you know, the kind of the crisis that we were in earlier with, you know, natural gas that's 3 times higher than it should be. Would you use that prudency method to say, and you had another option that wasn't 3 times higher for natural gas? How would you address that within that proposal to say, hey, you can't use that source that's 3 times higher, you must use this
Let's say
source
use the source that's
Commissioner
that's
Sullivan.
lower.
Okay.
Sorry, I'm
That's
sorry to not
You're
go through
good.
the chair.
Okay.
I mean, that's what I would say, and that's what we would do.
Sounds good.
Yep.
Madam Chair?
Representative Swazinski.
So like in the areas, let's say, like solar gardens. So like that's an area where we have rates that are 4 times more than industrial solar. How does that prudency, when you approve that or not approve that, how does that process work within your jurisdiction?
In the context
Sullivan.
of, thank you, Chair Acom. In the context of solar gardens, that's a state program that the legislature has enacted. So, is therefore in the public interest.
Representative Swazinski.
Madam Chair, but if you have I understand that you don't approve those are just come online, but, you know, if it's displacing that, you still have an obligation to ratepayers through the prudency rules that you have to follow. That if it's an imprudent investment, that we essentially don't allow that to displace industrial.
Commissioner Sullivan.
Chair Acom, Representative Swedzinski. I mean, it's a good question, and I would say that the legislature has made the determination that it is prudent to make those investments. So that is not a punt. That is the way that I look at it. The legislature has made that determination, and what I would say is, how do you shift sand around in the sandbox? Excel has met for the most of their solar obligation with solar community gardens. We're not, they don't have to go over and above, so. I mean, but now, just to be clear on that too, solar is a very cost-competitive resource. So we've just recently ordered a significant amount of solar.
Industrial.
Representative Swedzinski.
Thank you, Madam Chair.
I would call it utility solar, yeah.
Okay. Utility.
Utility-owned solar.
Good. Sounds good. And just kind of just reaching back, Madam Chair, sorry, I didn't go through you, I
Representative
apologize. We had that earlier conversation with, you talk about, and I agree 100% with your answer that, that was the wish and goal of a previous legislature with solar gardens to kind of put them to the front of the line whenever development happens and allows that to get rid of, would you say, utility solar. Just so if we're opening up, let's say with this, opening up the court case and allowing, you have to have a decision through you as an organization, a final determination on and then the judiciary can now get involved in individual cases. And we've seen in the past where individual cases can be used as case law to then force you as another agency to then, if a judge tells you, so not only you're going to have legislation coming from the legislature, but if you happen to have an activist judge on an individual case level that says, well, and it was talked about in the testimony where, hey, if we make a determination through judiciary, push it through, we might be able to not only affect that individual case, but a blanket of cases that may be shown same and similar. Do you feel like that would be used as a tool to then circumnavigate a future legislature to essentially come up with case law, come up with determination, come up with things that was never passed by a legislature, but now that you, a judge someplace, made that decision that you as an agency, as an appointed board, would have to then follow and enforce to future regulatory decisions?
Commissioner Sullivan.
Chair Aiken, Representative Swedzinski, I'm focusing in on the connection of the comment, and I don't see it that way. Going back to the bill that you heard before, I do not see it playing out in the way that you've sketched out. And my sense is that it's really fundamentally a due process issue, that somebody does not have they don't have an outlet. There's a procedural block to them at the current commission, and this is a way that they can work through it. In regard to community solar gardens, if that's kind of where you were, I think that state statute's pretty clear that there are strong benefits to the program, which the legislature recognized, and that's why I put it in place. And I think that I'm opining here, but I don't see a constitutional issue that a court would throw it over in. Certainly not through our process.
Madam Chair, if I could just jump in to clarify, where I think you're going, Representative, is all of our agency decisions right now are subject to judicial review. And we have a procedure where you first need to file reconsideration, and you have to kind of exhaust your administrative remedies, and then you can challenge in court. What Mr. Elwood in the legislation that Representative Stephenson brought forward is when our consumer affairs team, when they resolve consumer disputes, they're doing so under informal rules. They're basically problem solvers. That doesn't produce an agency decision. So there's nothing there to challenge. I think that's the area of law that he was trying to get to. So it's fairly narrow in that regard. Now, granted, this isn't an endorsement of or a critique of. It's just, I don't see the connection between that and the broader body of work at the agency, if that helps clarify.
I'm good. Thank you, Madam Chair.
You're welcome. Next, we have questions from Representative Kraft.
Thank you, Madam Chair. Commissioner Sullivan, actually, this is the slide. I'm interested in some of the conversation around natural gas and the comment of 2 to 3x, but I also see on here concerned about the gas price spike. Have you also seen that the price of natural gas has been very variable over the past several years, or has it been consistent? What have you been seeing?
Commissioner Sullivan.
Yeah, I can speak to the natural gas spike. That was the President's Day weekend 2 years ago, where because of the polar vortex coming down into deep into the center of the country, wells in Texas froze, and they were unable to export gas into, basically they were unable to supply. And what we saw during that week was literally, I mean, a massive increase in the price of gas. I believe for the weekend it was around 150 times the normal price. The testimony that we took in the record and the investigation was that, you know, folks at the gas utilities had never seen anything like it, had never seen a run-up like that. And, you know, that event was driven by, you know, climatic uncertainty from climate change, the polar vortex coming down deep into the country. What the commission did is open an investigation, which ultimately disallowed certain expenses for the utilities, primarily expenses that were made. There were 2 gas purchases that were made, and most of our decisions were, the bulk of the disallowances were made on the second day of the second set of purchases. And that's how we came to our disallowances. The larger question, if natural gas, are we seeing more variability in the price of gas? I mean, that was certainly an event which my fear is that because of climate insecurity, climate uncertainty will happen more often. But in terms of like the market, are we seeing, you know, swings in the market? I am not I don't follow the gas market on the, you know, like Representative Garofalo does. I don't have the Henry Hub price up. But the market price has settled in at a price that is higher, 2 to 3 times higher than what it was 3 years ago. And there's a number of reasons for that. But the price is kind of settling in in a range that's higher. Its range is higher than it was before. I hope that answers your question.
Representative Kraft.
Madam Chair, yes. Thank you. And I guess I was interested in you pointing out that this fuel charge has been a significant driver.
Yep.
And I was going to ask, but I appreciate you pointing out that the fuel charge for renewables is 0. Mm-hmm. And I would also say that the variability in the fuel charge for renewables is 0.
Right.
And the other thing that I think is really interesting is if you look at the rate comparison there, and I understand Representative Garofalo had some questions about it, but I think you addressed that a lot of the reason that we're seeing that is conservation, not necessarily mix. Mm-hmm. But if you consider that Minnesota's renewable percentage is well above the national average. I think we're at about 29% versus a national average of 20%, and our renewable percentage is much higher than our surrounding states as well. To have lower rates as well, I think also is a point to note. Mm-hmm. It was more of a comment. I do have a question on a different topic, which is in your measurements about saying are we being reliable, it was a measurement about the amount of time it takes to restore from an outage. Mm-hmm. And this may be a new member type of question. Why isn't there also a measurement on the amount of outages? Or why do you measure it this way versus a different way?
there is a measurement on that, so.
Yeah, Madam Chair, Representative. So the graphs we chose to use here, we used what's called results-based accountability. There's a whole lot of metrics across the industry that capture a lot of different things. We're trying to use a metric that can be most easily condensed for a lay audience. And in this case, so to your question, it's called SAFE, the System Average Interruption Frequency Index, and it looks pretty similar. It's not as a statistician would probably contest what we're doing here, but we try to bundle them together with all of our investor-owned utilities to compare them to their peers across the country. So there are a lot of different indices and different ways of looking at this, but on the reliability side, in terms of duration of outages and frequency, our utilities perform pretty well. Yeah, and it also, I'm going off script here too, which is also dangerous, but it's worth noting, right? We regulate investor-owned utilities. All of those utilities look very differently. They have a very different profile for generating electricity. They have a very different profile in terms of the customers they serve and their rates, and these metrics vary across their systems too. So you can't draw one-size-fits-all conclusions across the board. We're trying to average them in a way that's as accurate as possible, so at least we can understand in the context of their peers nationally how we're doing.
Representative Kraft, can you follow up?
Thank you, Madam Chair. One more quick. So I appreciate that. I appreciate you trying to address it to a layperson. I would ask that it would be interesting to me to see not just how the outage restoration, but the overall reliability data in some way as you see best fit to deal with a layperson, but I think that'd be helpful.
Any other questions? Seeing, Representative O'Neill.
It's good to have you here, both of you. It's great. I just have a quick question about Solar Gardens rate versus utility scale. And maybe you don't, nobody probably knows like the exact amount of utility scale because it's a bit varied, but can you just let us know what the difference is between utility and Solar Gardens, their production rate?
Commissioner Sullivan.
Thank you. Okay, I believe that there is approximately, the Solar Gardens are reimbursed at the value of solar rate, which is a tariff that the legislature requires that is set up. It's built up of several components, and I want to say that it's about 13 cents. Logan is right there. It's about 13 cents a kilowatt hour. So that is which is right in the range of what the retail rate is, somewhere in that range. Now, what the wholesale rate of solar is, that varies by project to project, but it is lower. Wholesale prices of, you can see some of the most recent data that is in, EIA pulls together that data, and there's various sources, but wholesale rates and power purchase agreement rates, you're looking somewhere in the range of probably $50 to $70 a megawatt hour, which translates to 5 to 7 cents a kilowatt hour.
Representative O'Neill, any follow-up?
Yes, thank you. So, thank you, Commissioner Sullivan. Can you be more specific as far as, you had mentioned Xcel. So Xcel is compelled to purchase Solar Gardens via us. So we have written legislation back in 2013, and that was our now Speaker Hortman that wrote that legislation. And it, as you say, mandated that Xcel Energy purchase the Solar Garden power, and that rate has changed throughout time. And if I remember correctly, it was higher, maybe 14 cents a kilowatt hour. And the PUC intervened and brought it down slightly. So the older contracts are the higher rate, which I think it was around 14 cents. And maybe, I don't remember the exact number, but higher than it is now. And so those contracts continue, that Xcel Energy has to continue to pay those higher rates And as you said, they're kind of at capacity with what the renewable energy standard has asked them to purchase. Versus if they went out and either did a purchase agreement or built their own solar fields, which they're kind of doing a mix of utility scale solar. Can you let us know the range for Xcel Energy? Because I understood it was less than 5 cents per kilowatt hour. Is it less than that, what they're currently purchasing or with the utility scale?
Commissioner Sullivan.
We can get back to on what those numbers are. I think that I think I'd like to get back to you on what those numbers are. I guess I would go back to my previous answer, like the wholesale price is lower, and Community Solar Gardens was intended to be a customer-focused program, and there are programs that are set up by the legislature that are customer-focused, and it's been a very popular program. In terms of solar in the state, I think that within the state over the next decade, CSG will be dwarfed by the amount of solar that's coming online that's been included in utility resource plans because the commission and the resource planning process and the stakeholders and the utilities have proposed putting in a significant amount of new solar. So I guess I look at CSG as a customer-focused program that tends to be, it's very popular, and so I don't know if that's the answer you were looking for, but.
Any follow-up, Representative?
Thank you, Madam Chair. Of course, it's popular because it's very profitable for those that are doing it. You're talking about providing utility scale solar, which I would argue is actually less than 5 cents, but you can correct me if I'm wrong, but I believe utility scale solar is less than 5 cents a kilowatt hour, where Solar Gardens currently is at 13 cents, and it was higher before there was an intervention. So of course they're interested because they're making a lot of money. I mean, so much so that, as Representative Swedinsky has said in the past, farmers are being paid an incredible amount of money to lease their land for 20 years. I had heard a figure of $1,200 an acre, and I think it's even higher. I think Swedinsky, it's higher, 14. Okay, so now we're up to $1,400 per acre for 20-year contracts. So of course they're interested. In fact, I remember the last time I was on this committee, there was so much interest that people from around the world were coming here to do solar gardens because it was so incredibly profitable. And one might argue that those that are profiting are corporations and millionaires and billionaires. I think Representative Swedinsky has talked to that in the past. But I think that as a legislature, I think it's really important that we look at the facts, that we look at, if we want solar, I think it's important that we do it in a way that's affordable, that's reasonable. And by the way, I don't know if you caught this, members of the committee, but the solar gardens are not regulated by the PUC. So it is a little bit of a wild, wild west out there because Xcel Energy is compelled to purchase it while they do have to accept it onto their grid. It is not regulated by the PUC, and it is extremely expensive compared to the wholesale cost of utility scale solar. I don't have nearly the issue. I have smaller issues with utility scale solar because you do regulate that, and which I find very helpful that you do regulate that. You're making sure that it's properly sited, that it's properly maintained, that it is decommissioned at the end. I know we've talked a bit in here about recycling of solar panels, and I would point out that what we've heard in here isn't completely accurate because while solar panels are being recycled, it's a misnomer to say the entire panel is being recycled. It is 75% glass, which can be recycled. The aluminum frame can be recycled, but the film inside of it is, for the most part, landfilled unless there's some other process that I don't know about. I was just researching this with EPA. So any case, I think it's important that we, the legislature, are fully informed. And I realize that we've got a whole bunch of brand new people in here. We've got the largest freshman class, I think, in our state history. So I think these matters are important to discuss in the reality of what they are with the true prices that we know, and that we actually have created the Solar Gardens program that that has been incredibly successful if you want to look at who's, there are a lot of it, and they certainly are benefiting a certain contingency of people that are rather wealthy for the most part. So the last thing I would say, I just have one other quick question for them, and that is the Sherco project. And I'm still trying to wrap my head around the integrated resource plan that says Sherco will be decommissioned because it's 2,400 megawatts. And I realize there's a lot of new people in here, but that is a lot of power. That is one of the largest power plants in the Midwest, 2,400 megawatts of power that is now going to be fully decommissioned and replaced with 430 or 460 megawatts of solar, which, by the way, that is not an apples-to-apples comparison because the Sherco power plant was a 24/7 baseload power plant that was producing 2,400 megawatts on demand as much as you needed, where solar, of course, in that latitude is at best 13% of the time it's producing the nameplate capacity. So I just want to know, like, just briefly, like, how did you decide to approve the IRP where you've got this massive decommissioning of a 2,400 megawatt per hour coal plant, replacing it with 430 or 60, whatever it was, of solar?
And as I turn it over to Commissioner Sullivan, I would also say I think they decided not to continue with that plant because coal isn't as cost-effective as solar. And so keeping costs in mind, it's a really important aspect as well. And when we talk about solar, there's a lot of different customers for solar, whether it's rooftop on people's homes or for those people that can't have solar on their homes to be able to buy subscriptions into community solar gardens and utility grade as well. So anyway, I will let Commissioner Sullivan answer the question, but we will certainly continue conversations around solar.
Thank you, Chair Acom. Representative O'Neill, it's an important question, and I sympathize with folks who are like, how could you replace a 2,400 megawatt power plant with 400 megawatt solar facility? I understand conceptually that it doesn't seem to fit. But that's not the way that we look at it when we're doing a resource plan and we're looking at the system. When we're looking at the system, we look at all of the attributes that 2,400 megawatt power plant brought to the system. And we look at its availability throughout the year. We look at the amount of energy that it generates throughout the year. We look at really detailed things like frequency support or frequency modulation and really deep stuff. And we look at all of these attributes. And what we can do through careful planning, which is what our utilities and the engineers at the utilities are excellent at doing, and MISO has said that the Minnesota planning process is, if every state throughout the MISO footprint did it as well as Minnesota, we would not have issues. So I take that as a point of pride, that we do a very good job of planning. But we look at that power plant, we look at every attribute that it provides, and then our planning process finds the solution set. And that 2,400 megawatt power plant can be replaced with a couple thousand megawatts of solar, a couple thousand megawatts of wind in strategic spots, a couple, thousand equivalent megawatts of savings that you get through your conservation programs. It can be replaced with some solar, with storage, which has the frequency support. So you can knit together through that process, and the utility can knit together through that process a way that you replace every attribute of that power plant. So just because you're looking at that one 400 megawatt solar facility in Becker, that's not what replaced that. What replaced that are literally wind farms, energy efficiency, storage, solar throughout the footprint. And what the benefit of that is that when we do that planning process, we don't plan for a more expensive system. It is less expensive. The attributes being replaced through all of those different means is less expensive than what it replaced. So least cost energy or least cost efficiency planning is what we do.
real quick, Mr.
Yeah, Madam Chair, and while not a satisfying answer, I would just say, and you'll probably hear this refrain throughout the session, the commission speaks through its orders. And so I think to that end, I'm happy to send you the order for the Excel resource plan because our orders do document the rationale and the thinking of the 5 commissioners and what the decision is, how we arrived at that. And so it's another point of reference that hopefully is useful to you.
And with that, I want to thank our testifiers from the Public Utility Commission for being here today. Thank you. And with that, we are adjourned.
Thank you.